Hey everyone, it's Squid. Welcome back to the channel. How are you guys doing this afternoon? Oh my goodness. If you hear baby Squid crying in the background, she is angry because her father went to pick up dinner and didn't take her with. Caveat, if he was going to take her with, she had to put on a clean diaper. She wanted to throw a temper tantrum and want a clean diaper, so now she's angry that daddy left without her. Oh, the perks, the problems with being a toddler. Life is so difficult, changing those underwear. How is everybody doing today? Oh my goodness. It's a joy. It's a joy. We are going to get straight into this. I have to go to work tonight. So you might hear her in the background. She's very upset right now, but there's nothing wrong with her. Yep, it's the consequence for not changing your diaper and going to get your shoes. Like it. Jeff, shush. She's fine. Like, how is everybody doing? Yes, on your way in, smash that like button. There's 33% of the people who watch my videos are not subscribed. I know 5 of those are probably my hate watchers who claim to hate me, claim I'm this horrible person, yet watch everything I do. So with that being said, the other 27%, 28%, because I can math, y'all hit that subscribe button. We are on our way to 4K. The goal is 4K by Memorial Day. Don't know if it's going to work, but yep, she just wants her daddy, but daddy left without her. Teenage boys do the same thing. Yeah, you got to put on clean underwear before you leave the house. I saw somebody's comment, mine got mad and cried and refused to go to bed, and I said no popcorn. Yeah, life of a toddler. Like, life of a toddler. And Terry, 199, thank you for the $1.99 super chat. Isn't this from BBB Vice Randy? This is response from Randy to Bubbles. This is Bubbles, or response to Bubbles' final motion. We will see what has to be said, or what is said, and you will see that it is a Randy. Yeah, it's the actions and consequences, and yeah. I can't believe you would make your baby suffer the consequences of her decisions, actions. Well, it's better her than Mr. Squid ending up with a diaper that leaks while they're in a place of business. So it still gives you views on subscribed. I appreciate you, Sharon. How have you been? All right, this should be. We'll see how this is, because usually I would expect snark. I did check Fed 2 today, and there's nothing so far, but I saw somebody's comment about Lynette filing something because she didn't know she had to. Yeah. And Jeffrey, I saw that you sent a message in Discord. I had family stuff to worry about, mainly trying to get her to change her diaper. And I did change her diaper after he left. And then she tried to run outside like I, changed my diaper. I'm ready to go. And daddy was already gone. So, it's this. I don't know what I'm expecting from this. I'm not expecting any snark, although this is the one time when I would really want to do it as an attorney. But if you are new to my channel, I am all about courtroom decorum. Doesn't matter who you are, doesn't matter how snarky or bitchy or unprofessional the other side is. You need to be as professional as you have to be. Plus, my kind of petty is when someone is unprofessional towards me, I am uber professional towards them, because that makes them look worse. And if you know my kind of petty, Charlotte Dobre, I'm a petty potato. I would love to talk to my petty potato queen sometime. That is a life goal, but side note. All right, let's get into this. Response to motion for attorney's fees under 28 U.S. Code 1927, document 131. And I'll make this a little bit bigger for y'all. Plaintiff Jeremy B. Hales, by and through undersigned counsel, responds to the motion for attorney's fees under 28 U.S. Code 1927 and states, 28 U.S. Code 1927 requires something more than objective unreasonableness. The statutory language is unreasonable and vexatiously. The courts have not quite come to an agreement on what vexatiously means, but vexatiously clearly means something more than unreasonably. Footnote 1. Statute 1927. I just asked if she wanted a snack, and no! Okay. Statute 1927, counsel's liability for excessive costs. And I'm sorry about my poor reading today. Any attorney or other person admitted to conduct cases in any court of the United States or any territory thereof, who so multiplies the proceedings in any case unreasonably and vexatiously, may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. 28 U.S. Code Statute 1927, Lexis Advanced through Public Law 119-3, approved March 14th, 2025. Give me 1 second, guys. There is a difference between letting her cry and then just being neglectful. Yeah, she is protesting. And Patrick, thank you for the $5 super chat. All parties have waited, and now we wait. Next week will be hot, hot, hot. I think the judge is going to take every second of that 30 days. I did post a community post the other day, which with some 4 a.m. thoughts, because for those of you who are new here, I have insomnia really bad. I pay my bills. I do my best bill pay and thought processing between 2 and 4 a.m. I had some thoughts about why the judge did and didn't do what he did. Remember, we talked about how long those documents are, the federal rules of civil procedure, the Florida or the local rules for the Northern District of Florida, the American Bar Association rules of professional conduct, Florida's rules of professional conduct, all the case law. He has a lot to go through. I think he's going to take every second of that 30 days to make sure he has his T's crossed and I's dotted and everything is where it is. Monetary sanctions are easier. It's easy. It's like, here, you screwed this up. I want this amount of money for it. Write your check. You write your check, you're done, you move on with your life. But Bubbles did. It's just a little bit more serious and takes a lot of thought. And I'm sure this is the first time that this judge has ever had this situation and needed to deal with this. So he's probably also consulting with his clerks and all that to get their experience and input on what he should do. Because this not only affects Bubbles' career, but it affects his too. So we all have to remember that it's not just Bubbles. And for those of you who are new here, the reason I got involved in this case was because Bubbles talked about my child choking and threatened to call CPS on me. So I am talking about this case, just reading the documents and giving my opinions purely on the documents, just to piss off Bubbles. And I know that the more I talk about this case, the more he gets angry and the happier I get, because that's my kind of petty. Anyway, I'm moving on. Apparently clerks are judges. Clerks are lawyers. I don't know if all of them have been judges in the past, but they are all lawyers. Because he was a clerk for another federal judge back in the day. So it's yeah. Oh yes, and I agree, but it's not knowing how somebody screwed up that is the conundrum I see this judge having. It's what to do about it. What is in his purview, what is not, what would be too light of things to do, what would be too heavy. There's a happy medium that he needs to find himself in, because he does not want to be the person known as being too lenient on people, but he also doesn't want to be, if I were him, I don't speak for him, I don't know, I would love to have a conversation with the judge because he fascinates me, but that's a sidebar we don't have time for. Yes, karma is a being will get someone every time Bubbles is coming. Karma, as our petty potato queen says, karma is a bitch, and she always collects her debts. So I got to go back up. Amelong PA v. Denny's Inc. We've mentioned this case before. 11th Circuit, 2006. The 11th Circuit Court of Appeals held that an attorney's conduct will not warrant sanctions if it simply fails to meet the standard of conduct expected from a reasonable attorney. And we don't exactly know what Bubbles, if Bubbles is a reasonable attorney. Based on other cases that I've seen him involved with, reasonable and him should not be in the same sentence. But that's just me. Thus, in Schwartz, we wrote, Section 1927 is not a catch-all provision for sanctioning objectionable conduct by counsel. For sanctions under Section 1927 to be appropriate, something more than a lack of merit is required. The statute was designed to sanction attorneys who willfully abuse the judicial process by conduct tantamount to bad faith. Bad faith is the touchstone. Section 1927 is not about mere negligence. A determination of bad faith is warranted where an attorney knowingly or recklessly pursues a frivolous claim or engages in litigation tactics that needlessly obstruct the litigation of non-frivolous claims. Schwartz 341 third district, no, whatever. Sorry. Little bit and somebody also didn't take a nap today because Slug told her that naps are for babies. So everyone in this chat is better behaved. Yes, and in this chat you will hear opinions that you might not agree with. Yeah, remember to thank Bruce for introducing you to so many people. I bet he'll love that. Yes, thank you, Bruce, for introducing me to so many people. So many people. I appreciate you so much. I blame Slug. Yeah, it's all Slug's fault. And he just sent me he just messaged me something. Oh my goodness. He's crazy. You got to head out to prep for stream later. Remember to show what I sent you on text. It's very funny. Off I go to prep for stream at 5 p.m. Yes, it is very funny, but what are they riding on? Vacuum cleaners? Are those Roombas? Yep. That's hashtag blame Slug. Hey, my pretty. How are you? Blame Jeremy. Yeah, everything's Jeremy's fault, right? Just everything's. Yeah, she's tired. Oh, trust me, I wanted to take a nap when she did. Oh my goodness. An award of section. Thus, an attorney's conduct must be particularly egregious. Remember this phrase right here, because who does this apply to? To warrant the imposition of sanctions, the attorney must knowingly or recklessly pursue a frivolous claim or needlessly obstruct the litigation of a non-frivolous claim. Who does that sound like? An award of Section 1927 fees requires three things. One, that an attorney engage in unreasonable and vexatious conduct. Pot, meat, kettle. Two, that the conduct itself multiplied the proceedings. And three, that the dollar amount of the sanction must bear a financial nexus to the excess proceedings. See Peterson v. BMI Refractories, 11th Circuit, 1997. Determining bad faith for purposes of a Section 1927 claim requires a court to look objectively at the conduct of the attorney, not the attorney's subjective intent, to determine if the actions of the attorney represent intentional or reckless disregard to the attorney's duties to the court. See Norellis v. Denny's, 11th Circuit, 2010. Denny's been sued a lot. Make IP LLC versus City National Bank of Florida. U.S. District, Lexus, Southern District of Florida, March 11th, 2025. Ooh, that was super recently. The intent behind Section 1927 is to sanction attorneys who willfully abuse the judicial process by conduct tantamount to bad faith. Rosella v. Chauncey, Middle District of Florida, September 1st, 2023, citing Hyde v. Irish, 11th Circuit, 2020, stating that a Section 1927 movement must show objective bad faith by their opponent. And I don't believe, yes, Randy has had his fair share of unprofessional moments, but I don't think anything that he's filed has been in bad faith. On the other hand, I believe that someone has filed some things in bad faith. Like, I don't know, BCCing me on a settlement agreement. No, that's bad faith. Like, that is bad faith. One, Amanda Martin's deposition. There is no objective bad faith in taking Amanda Martin's deposition. Parties may obtain discovery regarding any non-privileged matter. Baby girl, I'm going to put you this way. There we go. That is relevant to any party's claims or defense. Federal Rules of Civil Procedure 26B1. Information is relevant if it appears reasonably calculated to lead to the discovery of admissible evidence. And knowing that she had a lot of contact with Lynette, and y'all call her a bunch of names, you guys do you. Because I'm trying to stay as neutral in this as possible, I will always call her Lynette. I don't call Bubbles, but I call Bubbles Beelzebubbles, Bubbles, BBB, anything, because he personally went after me. And I have the IP address traces to prove it. That's not the point. Because Lynette, I will never personally attack anybody who didn't actually do anything to me. So y'all can call her whatever name, whatever names you want in the chat. Just know that if I don't, it's me being just, because I have both sides sometimes accusing me of being like for the other side. And it's like, no, I'm calling balls and strikes as I see them. Yeah. Here, plaintiff's counsel had a right to take the deposition of Miss Martin because, one, Miss Martin knew Mr. Hales in 2023 as his victim's advocate by virtue of the Ohio protection order in place, restricting Miss Preston from having any contact, including third-party contact, with Mr. Hales. Miss Martin knew Miss Preston in 2023 as her victim's advocate. And three, Miss Martin's adult son, Steve Rhett Cunningham, assaulted Mr. Hales in 2023. Prior to this assault, Mr. Hales never knew Mr. Cunningham. This means it is certainly objectively reasonable to take Miss Martin's deposition and inquire to the facts surrounding the above circumstances. Totally agree with that. You still get the random unaliving threat from both sides for not insulting either. Yeah, I don't understand that. And never, no matter how much we dislike people, never ever throw around threats that you can't, because there's certain things in life that once you say them, you can't unsay them, and they have real life consequences. So sometimes you're just better off just not saying anything at all. And once again, I don't hold anybody hostage here. I don't have anybody taped to a chair, despite what Slug and DJ Radis say to you. I don't have them taped to a chair somewhere, forcing them to watch my streams. Everybody's here out of their own free will, and you will hear people in chat that you don't agree with. There are some people in my chat who are regulars in the haters channels, but they are pleasant here. They have been nothing but respectful to me. And once again, I'm not going to, what y'all do in the other 22 hours a day I'm not streaming as a you thing. I don't care. Like, I'm not in high school anymore. Like, I'm not in high school anymore. And it's good. I did not. Ooh, yeah, she is asleep. Whew. She had passed out hard. Oh. Documents 85 and 86. Movant states documents 85 and 86 were based on flagrantly false premise. Document 137 at paragraph 7. The court has addressed this already. Movant does not and cannot show that documents 85 and 86 were done with an improper purpose, such to harass, delay, or increase cost based on a flagrantly false premise. Oof. Double. Yeah. I'm all for, like, my high school English teacher, and I have a background in the medical field. So for those of you who are new, my background is in occupational therapy. I have a background in medical and business writing, so I get very particular when I see like this. When I start seeing, and this was my huge issue with Bubbles filings, when I start seeing grammatical errors, I start to hyper focus on the grammatical errors, and you lose my focus on what the document is about. When things are in there that don't matter, I start to lose focus. And I've had brain surgery, so not to use that as an excuse, but sometimes, Legal citation dispute. The Blue Book style guide used in the American legal profession for citation of all relevant sources, footnote 2. There is no objective bad faith when Movant's citation to Shanahan v. Cahill was made in violation of proper Blue Book citation. I mean, that's true. The Blue Book, a uniform system of citation. Hey, they used Purdue OWL. I used Purdue OWL in college. And no, I didn't go to Purdue, but I still used Purdue OWL for almost everything I did in business writing. I had a creative writing class, and I even used Purdue OWL then. Like, Purdue OWL was my favorite go-to. Specifically, Movant was trying to cite a quotation of 88 words from Shanahan v. Cahill, 4th Circuit, 1995, by using quotation marks, not indenting 5 spaces from the left and right margins, using... That's good to know. Now I know how many indents those are. You learn something new every day. Using double spacing and by using emphasis without clarifying whether or not the emphasis was in the original quotation or added by the Movant. Here is the Movant's quotation from these 88 words from Shanahan v. Cahill, 4th Circuit, 1995. Oh, the questionable 88 words. In particular, it is important to consider whether the amount claimed in the complaint was made in good faith or whether plaintiff was consciously relying on flimsy grounds to get into federal court. See Rosado v. Wyman, 1970. Supreme Court, 1970. Distinguishing initial insubstantiality from subsequent mootness. And that's one of the judge's favorite words is moot. Another critical equitable factor is the existence of any state limitations, bars to refiling in state court. See Reidenauer v. Andrews Federal Credit Union, 4th Circuit, 1990. Shanahan v. Cahill, 4th Circuit, 1995. It is undisputed that this quotation is more than 50 words. Pursuant to Blue Book, footnote 3, quotations of 50 or more words should be single space, indented on both sides, justified, and without quotation marks. This is known as block quotation. And that's the media.law.miami.edu. Blue Book Workshop, fall of 2011. Hoy. As long as Slug respects baby's good and Space Latina is the chameleon ambassador to the... Wait. Nope. Over my head. You tell her that. I'm not getting in the middle of that one. Quotation marks within a block quotation should appear as they do in the quoted material. The citation following a block quotation should not be indented, but should begin at the left margin on the line following the quotation. Do not use quotation marks. Indent the entire quotation 5 spaces from the left and right. And left and right margins, single space is required. I just can't. Like, I am so, yes, right here. Randy teaching Deuce a lesson. Like, y'all are like, and this is where like Randy's become my hero, because I am that proverbial when people say things like grammar Yahtzee, that is me. If like, if you have annoyed me, like on Facebook, when you can get in Facebook jail very, very easily by someone just being moody. When someone annoys me, I hit them with the bless your heart and the grammar police, because I know it'll get under their skin. Like I said, petty, but there's a level of petty. Like there's an annoying level of petty where I know I get under your skin and I'm going to keep doing it. And then there's the illegal petty. We don't subscribe to that. And Cynthia Miller, thank you for the $20 Venmo. I say, just because you keep demonstrating such patience with baby squid that I'm compelled to acknowledge it. You give me hope. I try. Like, I do understand that, like, there's a difference between her crying it out and learning, like, that there's consequences to actions, and then just being neglectful and mean. So, but she had packed out. Oh, all right. Here we go. You ready for the grammar police and the style police? You're the OT queen. I try. She's passed out. You want to take her and lay her down? Or you want to just leave her here?
Stay right there.
Okay. We're good. I got a footrest on this chair now, so I can... She's just warm. In particular, to correctly quote using proper legal citation formatting from the Blue Book, using the Movent quotation from Shanahan v. Cahill, would be as follows. In particular, it is important to consider whether the amount claimed in the complaint was made in good faith, or whether plaintiff was consciously relying on flimsy grounds to get into federal court. See Rosado v. Wyman, Supreme Court, 1970, distinguishing initial insubstantiality from subsequent mootness. Another critical equitable factor is the existence of any state limitation, bars to refiling in state court. See Ridenour v. Andrews Federal Credit Union, 4th Circuit, 1990. That is how you do it. There's more than 5 spaces and indentation on that citation. 3, 4, 5. No, there's about 5. And I'm sure he has it set up as a wait, Randy. Sorry. Oh, sorry. I just saw it. Wait, there was a comment that I just saw. And and Slug, thank you for the $2 super chat. You smell like stale Doritos. Viva la Slug. Yes, I'm sorry. Don't remember. Yeah, Robert here. But wait, Randy misspelled Blue Book as Blue Book while being the style guide police. Yeah, it's important. It's important to yeah, I gotta call Randy out on that one, dude. Like we gotta call this one out yet. Like Blue Book. Oh yeah. Anyway. And yes, I do have a channel gift list from Amazon. We moved into we bought a house a couple months ago, and we're working on making it cozy. And honestly, that where your money goes. Because there's been a thing lately about not knowing where donations go. That exactly where your money is going to. Remember that the fonts are proportional and the space tends to be wider than the letters like F and I from the follows. Yeah, there's a lot that goes into it that we don't ever think about. But here, Shanahan v. Cahill, 4th Circuit, 1995. Instead, Movent violated the requirement for legal citations in all the above ways. This kind of confusion could have easily been avoided hadn't Movent Here's another one. Randy, if you're going to call somebody out on grammar and like, I understand why you're doing it. Not that Randy sees these, but if he ever does, he told us not to tell you. I'm assuming this was Movent. Had Movent used proper legal citation, moreover, omitting emphasis added can be seen as misleading, as it might not be clear to the reader that Movent altered the original text by bolding certain words. That is true. That is true. Oh yes, and Baby Squid has a unicorn room with fairy lights on her canopy bed. All courtesy of y'all. In any event, it does not show that counsel so multiplies the proceedings in this case unreasonably and vexatiously. Dispute over court reporter. The same court reporter handled both parts of plaintiff's deposition. As part of normal attorney procedure, Movent's counsel secured a court reporter and thereafter received an invoice for the first part of plaintiff's deposition. Here we go, the money. For both the attendance of the court reporter and for the deposition transcript that was ordered. Plaintiff's counsel ordered a copy of the deposition transcript for the first part of plaintiff's deposition, which occurred by Zoom, and received an invoice, which was paid. During the second half of plaintiff's deposition, which occurred in person in Pensacola, Florida, the same requests were made. However, it was Movent's counsel who said nothing to either the court reporter present or plaintiff's counsel when plaintiff's counsel again ordered a copy of the deposition transcript. This created a problem because the court reporter was not made aware of the requirement that parties split the deposition costs for the second part of the plaintiff's deposition. Thus, the court reporter invoiced plaintiff's counsel with a second invoice for something that was not even necessary, a copy of the deposition transcript from the second deposition. When Movent's counsel should have stated to the court reporter that it would not be necessary for anyone to pay for or need to have a copy of this transcript because both parties were splitting these particular deposition costs. That means that both counsel would have equal rights to receive the deposition transcript from the second part of plaintiff's deposition, and a copy of that deposition transcript would not be needed. That's interesting. That one I didn't know. Hey, Rogue Mama. Dose reality. So Deuce came in trying to litigate the case and admitting he should be punished, even though he will no longer be on it. And Randy responds with just how badly Deuce should be punished. Yeah. It's, you don't, and I'm still confused. And if anybody can tell me this one, it's, why is he asking for attorney's fees when they're indigent and they aren't paying for it anyway? And he's pro bono? Please tell me what you want money to come out of nowhere. And even if it were, common sense dictates that the parties split the total costs for both invoices for the second part of the plaintiff's deposition. The confusion was finally cleared up by contacting the court reporter, who eventually did a post-mortem analysis of why there were two invoices for the deposition held in person. After figuring out what the problem was, the court reporter immediately issued a full credit for the overpayment made by plaintiff's counsel as a result of the Movent's counsel standing by silent when plaintiff's counsel requested a copy. You gotta speak up. And Terry, thank you for the $4.99 super chat. Do you still want the transcript from April 3rd? I needs help with the Dropbox. Yeah, I have to. It's not hard to do. I'm just boomer. I'm a boomer. I'm a boomer. So I need to figure out how all that would work. But yeah, I do want the April 3rd transcript. I just don't want to pay $440 for it, if you know. Squid, what about the money there is? That not my purview. I don't know. That's why I am super because of that question being asked, and one, I have no desire to investigate, because that would automatically put me on one side or the other. And yes, the facts lead me towards one side, and the fact that one side attacked me and one side didn't. Jeremy knows that I don't cover this case like anybody else, and I call both sides out when I think they made mistakes. Not like I'm a lawyer, not a lawyer, but I'm not afraid to call both sides out. Jeremy basically said, "You do you. It's your channel," and the other side said, "We'll call CPS on you because you're streaming and not taking care of your daughter." Exhibit A. So, you know, and Drew Terry, thank you for the £5 as ever. Thanks for the coverage as ever. Oh my God, that's Drew. That's a rabbit hole as ever that we could go down. If you know, you know. No. There's Google Drive too, and I think that's what I'm going to do. I just want to make sure that I'm sharing it correctly and I'm not like screwing something up, because Squid leans towards one side because the facts, and you tend to lean towards the side of people who don't attack you. But I try to be as neutral as possible. All right, the confusion finally cleared up by contacting the court reporter. Eventually did a post-mortem analysis of why there were 2 invoices for the deposition held a person. After figuring out what the problem was, the court reporter immediately issued a full credit for the overpayment made by plaintiff's counsel as a result of the movant's counsel standing by silent when the plaintiff's counsel requested a copy. We talked about how sometimes you need to open your mouth and say something. It is untrue that the court reporter never sent the invoices to plaintiff's counsel. In fact, everything was paid from these 2 invoices by plaintiff's counsel. The confusion about who was splitting and who needed to order copies of a transcript does not rise to objective unreasonableness or show that counsel so multiplies the proceedings, in this case, unreasonably and vexatiously. Yeah, you never bringing up money and like who's going to pay for something and the confusion about how something got mixed up, because I can see how that would get mixed up if 2 counsels aren't getting along. Communication is very poor between counsels. And then you decide that money becomes an issue. If 2 people already don't get along and have poor communication, money is going to be a problem. DJ Radis says, breaking news, Lisa Flea wrote an apology letter to her fans. Oi. Yeah, Debbie, she cried for a little bit, but then when I knew that she was not going to stop crying on her own, there's a time limit that I give her where, okay, she's not going to calm down for anything, no water, no space, and then she passed out. So, Hugs, babe, waiting for your promo drop. Yeah, we have to talk. All right. All right. Conclusion. Movant's basis does not show that counsel so multiplies the proceedings in the case unreasonably and vexatiously. The motion should be denied. Respectfully submitted, Shockett Law Group. And this is how you get petty and you like say facts. And this is where you prove somebody wrong. This is what every one of Randy's motions should have been like, because he got snarky in the motions. And yes, it was funny, but we all know that should not have been. We all know that should not have been done. So yeah, was it funny to do? Yes. However, Randy is a grown-up, adulting versus Brucing. Baby Squid for the win. Yeah, and it's like, yes, and there are still people who can't or say they don't understand why Randy got sanctioned. Randy got sanctioned, and his sanctions were appropriate. Yes, was he unprofessional? Yes, was Bruce worse? Of course. There is no denying. I really don't know any lawyer that goes on a podcast multiple times a week and talks about an active case. I don't know a lawyer that creates multiple YouTube accounts to harass other YouTube creators that don't want to talk to them. I don't know any lawyer that does that. And not that I talk to a lot of lawyers on a daily basis, but I've followed lawsuits long enough to know what people do and do not do. And there's very few times that counsel talks to media outlets about an active case, like during the case. Afterward, yeah, they will go on media tours all they want to talk about how they lost and they shouldn't have, or how they won and it's great. But I don't know any lawyer that's ever done this. And I'm not a journalist. You can ask Slug. But yet I got emails of Bruce wanting to come in here just because I didn't block him. And when I said no, he was super nice trying to butter me up. And then when I said no, went off the rails. And Debbie Baker, thank you for the $10 super chat for baby girl. She cannot have her way every time. Yeah, and she was just tired, obviously. I don't agree about Randy being sanctioned, but you don't see him crying about it. Yeah, and that's part of the thing too. He just took it and moved on. Spawn Trooper Crampon's apologies properly from a comic book. Oh boy. All right. And I do have a new trailer for my channel that I'm going to drop. Yeah, she's out. She is out. It's my cutie pie. But I have to get going. I'm going to check the docket for anything in the other case before we go anywhere, just to make sure that we are not missing anything. Oh, there is. oh. My apologies. We're going to get into this real quick. And I just have to save this super fast. New lawsuit 2025-418. And LP. There we go. All right. We are going to show this on stream. This is in the new lawsuit, the second lawsuit. And I will probably cut this part. We're at 47 minutes. I'll probably cut this and repost it as a separate video so that when people go back and they want to look at what the Hales playlist and they want this one specifically, they don't have to listen to the other stuff first. All right. No Gainesville division. Guess who wrote this? Yeah, I know you said they told you they would be, but a lot of the times it happens after under certain circumstances. But was this one of the circumstances? There's the that's debatable depending on who you're talking to. Thank you for keeping us updated. That's what I do. Motion to set aside default, and this I'm just not even going to judge the grammar on this because we all know that it was written by either Lynette or somebody or somebody else, and it's well, it's me. It's all Jay that did it. It's all his fault. Yeah, it's all everybody moving. Thank you. And Marcus King, thank you for the $9.99 super chat. It's like tomato. I always there's certain things that I say differently depending on the context of the sentence that they're in. Hey, Drew. We knew this set aside request would be incoming. Yeah, I kind of assumed they would be. Oh no, Slug's got bad news. Pursuant to Federal Rules of Civil Procedure 55C, Defendant John Cook moves to set aside default and ask for 21 days to please from the date when the plaintiff files an amended complaint as required by the court's order, document 117. Wrong case. Wrong case. Wrong case. Like wrong case. I'm just gonna state that. Like, I know you're not a lawyer, but you are a defendant in both cases. Yet your case is right. There is no document 117 in this case. We are only up to 25. As good cause, I am indigent and unrepresented. I am also being sued in another case in this court by the same plaintiff, which has most of the same allegations. He also in Ohio, where I have never been. Weren't they actually in Ohio, or were they on Zoom? Has a protective order that he weaponizes in Florida. It doesn't, no. I'm gonna call BS on that one right now. He doesn't weaponize it. He wants it enforced. There's a difference. Being upset that Florida isn't enforcing it like they legally should be is Jeremy's right to be angry about, if I understand that case appropriately. He has targeted me on YouTube since May of 2023. Yep, all Jeremy's fault. I lost track of the date I was served because I'm trying to help care for my partner's child while all of this is going on. And why this right here? Like, leave no matter what side you're on, leave the child out of it. Leave the child out of it. Like, leave the child out of it. And that's why Bruce and that side felt the need to attack me, because I talked about the child. He brings up the child in emotion where it's not necessary. Yeah, this is John. But there's 3 of them. So I just downloaded them, or go one at a time, because on these I can zoom in a little easier. Yeah, and that's my big problem. And that was what I had said when I was on somebody's podcast, that the hater channel saw and decided that my daughter was a target. And called me unhinged when I went into mama bear mode to protect my child. Like, oh, protecting my child is a bad thing. Like, yeah, this is more of poor me, pick on me, oh, me. I have so many responsibilities, poor me, not my fault. Yeah. I am in good cause, indigent. He has targeted me on YouTube since May of 2023. I lost track of the date I was served because I'm trying to help care for my partner's child. All while this is going on, and I'm sorry I missed the deadline because I'm not ignoring this or trying to avoid responding. This lawsuit is to fill YouTube stories using me as a character and using litigation to generate content. Jeremy had content long before this, and he will have content after this. Like, no. I'm pretty sure that Jeremy would have better content where he wasn't having to deal with the court system, because whether you're the plaintiff or you're the defendant, it's never fun and it's never cheap. You had 21 days. What's changed? I'm kind of sick of the woe is me. I'm sick of that, not just with this case, but like life in general, and everybody like woe is me for their excuses for their bad behavior and in general. Oh, baby. Yeah, I can. I might have to send them to you later, but because I have to work in like a half an hour. Are you okay, Angel? Daddy's home. Daddy's home. Oh, poor girl. She's warm. All right. This will be shown in defense of the claims in this case. I will ask for 21 days to file a response once the amended complaint is filed. No, you don't get to file. You don't get to respond to the amended complaint. You have to respond to the original, because the amended complaint was not for you. The amended complaint was for MLS. That MLS's lawyer asked for. I mean, just my thought that there's multiple questions with that. But those are things that are over my my head. Because responding to the existing complaint would seem pointless since a new one is to be filed in the near future, according to document 17. And then he complied with Local Rule 7.1b, emailing and waiting 24 hours. Mr. Shockett did not respond. So there's that. There is, this is LPs, and which LPs is the same. I'm just going to download it because Pacer charges add up, and I want to make sure that I don't have to pay two times. So give me a second to save this. There we go. Because my Pacer bill was $189.06. But that's for multiple cases because I have 4 cases that I'm following right now, looking at that are in federal court. So we're, yeah, and this is the exact same thing. This is the exact same thing. Except for it's Lynette's. So we are not going to read it because I don't have time. And then this one is a motion requesting appointment of counsel by John Cook, and it's 4 pages long. And I'm going to save this. 418. And as far as I'm aware, and I have read, you're not entitled to appointment of counsel in a civil case. All right. Motion requesting appointment of counsel. I, the above named plaintiff petitioner, do hereby swear that I'm unable to pay costs of said proceeding or give security. Therefore, that I believe I'm entitled to redress, and I'm unable to litigate this case on my own behalf because the attached respectfully request for the appointment of counsel. In support of this motion, plaintiff petitioner states that I have made a diligent effort to employ counsel and contacted the following attorneys: Legal Aid, Lawyers.com, Penny Coat. Nobody wants to touch this. Bruce Madskin was our attorney of record. No one wants to be on YouTube. I mean, fair enough. He thinks just because mom has a lawyer, everyone does. Your Pacer bill is $145. Yeah, it's 10 cents a 10 cents a page, but that shit adds up fast, especially if you I unclicked everything, so now it's like not as expensive to run a docket sheet. But if I were to run the entire docket for that first case, it's like up to like $2.30. It's ridiculous just to look at the docket, not even to pay for a document. It's a $1 million question right there. In support of this motion, the plaintiff petitioner states that I made a diligent effort to obtain the assistance of counsel by contacting the following legal aid organizations, referral service, or pro bono attorneys. I'm financially unable to hire an attorney because I'm on disability, and all our money is going to finish our house and pay our bills and care for HG, our child we care for together. I will give him credit. Small amount of credit, but give credit where credit's due. He mentioned her name, but he did not mention the fact that she's ill. I will. You got it. As much as I'm not a fan. You got to give some credit where credit is due, because I have a feeling if somebody else wrote this, that her health issues would be, yeah. On 404 photos, that is why I am because of all of that drama, Some I pay attention to, most of it I don't because I just don't have the bandwidth. That is why I am very open with how much my Pacer bill was. The fact that I have an Amazon list instead of like people used to donate to or give super chats for Baby Squid's room. Well, here's some stuff that we're putting in Baby Squid's room. If you want to contribute our Amazon gift card funds towards that, you know where your money's going. That way, I try to be transparent with that. Yes, I do this to help pay my bills. And I'm trying to grow my channel because this is my job. I'm a stay-at-home mom. But at the same time, I like to be transparent because when it comes to money, I don't play. I don't play. So, and that's his benefit administration letter. We are not going to read that. We are going to skip over it. Yep, there we go. So, we're just not going to read some of this because I don't want to get my stream taken down because of personal information. And I try not to be a douche because I don't want my personal information shared. So I try just not to show it. So he did write a letter to the judge. I am going to read it, but I'm not going to show it on the screen only because if there's things in it that I don't want my stream taken down because of. So I'll just skip those because I didn't redact anything. Dear Judge, I do not know how to write anything for the courts as an attorney would, as I am not an attorney, so please forgive me. John Cook and I applied to the courts. This is written by Lynette. At the onset of this case for court-appointed counsel, it was determined at the time this was not a complex case. But I truly believe now that Your Honor can clearly see this is far more than a complex case than as that we just normal everyday people who are being falsely accused of actions we absolutely and adamantly deny for use on YouTube videos to make money off our humiliation and the destruction of our lives for his monetary gain. And we are not in any way capable of defending ourselves against Mr. Hales and his attorney. There will be a trial and many witnesses to include experts and many exceptional circumstances that Your Honor could not have seen before now, and we are not able to deal with as attorneys for ourselves. We are also caring for, here we go, our disabled daughter with special medical needs, and that alone is a 24/7 job for us. We looked for counsel near us, and we were unable to afford to pay for an attorney, and the only person who stood up was Mr. Matskin from... Pay attention to this last... Pay attention to this because think about what happened in the other case and the motion that was filed when someone wanted out of the case and said he was fired. The only person who stood up was Mr. Matskin from Boston. He was threatened and harassed, as his wife was, and he threatened and harassed other people. And I have personal experience with that because he did it to me. And he feared coming here to Florida, and the expense out of pocket was way too much and hardship for him and his family. So, Your Honor, so they never said that. Do you notice they never mentioned that we fired him? He was the only person who stood up for us. Then why did you fire him? So, Your Honor, we are here asking again for the courts to appoint is each an attorney so we can be able to fairly defend ourselves from all the lies and false allegations against us. I emailed Mr. Stockett yesterday and he did not respond to my email, and I'm sure this behavior will continue from them. The last 2 years plus of court actions and being stalked by Mr. Hales and his friends and fans has caused both John and I and my 5-year-old, John helps. By the way, there's grammatical errors throughout this, but I have to go to work in like 5 minutes and I need to eat. So it's going to be a... Oh, Spawn, I got your message. I'm just in a hurry because I have to be out of the house in like 10 minutes and I have to eat. Caring for every child is a 24/7 job. Why should they get exceptions? Yeah. Oh, Bravo Zulu. I haven't heard that one in a while. Thank you. So much anxiety. We're all going to be getting counseling to help us all cope with this all. I have combined this as a letter for both of us, as John just cannot write like this and does not have the means to do so. What do you mean doesn't have the means to do so? You typed it on a computer, so did he. So can he. Sincerely, Lynette Preston and John Cook. So that is the end of that. Holy vey. So much fun. I do have to get going. I appreciate all of you for being here. There's 763 people watching right now. Holy goodness. Holy goodness. And I'm just going to make sure that I did not, and we only have 364 likes. Can we like get that to like 400? That would be amazing. Amazing. And thanks y'all for yesterday's video. It was my first video to ever reach 10K views. I'm just going to make sure I didn't miss any super chats. I think I got them all. I appreciate you guys so much. Yeah, she should have said that my lawyer made it worse. Yes, because whether you like Lynette, you hate Lynette, whatever side of this is on, you can not say that Bruce did them any justice and helped them at all. Like you can't say that he made this any better. In fact, he made this a whole lot worse because there are a lot of people covering this right now that would not have been covering this if Bruce would not have been as ridiculous as he acted. And I have the emails to prove it. I've shared with you guys all of his emails to me. Tug read some of them back in the day. But all of them are, 413 likes. Thanks, guys. You have a great day. I'm going to see if anybody is live that we can redirect to, because it's just a great day with lots of people, and it's a good Friday afternoon, and we're going to see who we can share the love with, because I am all about lifting up other people. You'll be live in 30. Should we redirect to slow it out? Flux is live. How about we go to Flux? We'll go to Flux. She's gaming right now. So y'all tell Flux. Yeah, pound that like. DJ Redis, I will show it. I just have to go. Like, I have to go. I have to eat and be out of here in about 8 minutes. I promise I will. Yes. Y'all go tell Flux that I said hi. I love you guys, and I will see you on the next one.